Our next speaker is Barbara Boulware-Wells. I'll get it eventually. Barbara is a principal partner for the Knight Law Firm and has over 31 years of experience providing legal services to both home rule and general law cities and local government entities and sub-entities throughout Texas. I would like y'all to welcome Barbara to the stage.
Well, I realize I'm standing between you and the end of your day, so I'm going to go through this. You'll be getting these PowerPoints after the fact, or you'll have them available to you, so you can read them at your leisure, and it's just scintillating reading. This is about conflicts of interest in the local government world. In essence, it's about ethics. And in essence, it really gets to the heart of whether you're a board member, a staff member, whether you're a consultant, whether you're an attorney, all of those people get impacted in the world of water when it comes to being on a board or coming before a board. So I'm going to start with board members. First of all, of the people remaining, who here is a board member? Okay. And who here are staff members? And who here are just wanting to be in here because it's cool? All right. So let's go with, I'm a board member now. And I'm going to, some of you who are board members, I'm going to get a little more personal, interactive here. Of you that are board members, how many have been on the board longer than 6 months? How many of you have been on there longer than 5 years? That's 6 months to 5 years, you've gone through maybe one session or two sessions, and whether you're elected or appointed, there is, some of you have at least come to learn that there are decisions that are going to come before you. And so you say, I'm a board member now. Do I leave my personal position at home? Now, your personal position may be completely in line and lockstep with whatever the board's rules allow. But let's just say it doesn't. My answer is, well, yeah, sort of. You are going to leave your personal opinion at home. When you've accepted the role of a director, you've accepted a fiduciary responsibility to the principles that transcend your personal beliefs and may even be contrary to those beliefs. And while you may not have known you were accepting a fiduciary responsibility when you accepted the role as a director, that's in fact what you did. These principles have clear ethical implications, and being a director means you accept the obligation to treat all persons fairly, even if those persons happen to have radically different viewpoints than you. Your viewpoints are not superior to theirs. What you have to look to is Chapter 36 and the board's rules. That's what guides you. That's what you are that's your guidepost, and that is what you are to look at when you look at the world of where your opinion is going to matter. Let's talk about fiduciary, because a lot of people, when they get on there, they don't even think that they're a fiduciary. It doesn't even cross their mind. As a public servant, and you are a public servant, when the public chooses either an elected or an appointed official, the public is putting that trust in confidence in that person to act as in the public's best interest. The same can be said when one becomes an employee of a public agency. So those of you who are employees, you are also fiduciaries to the extent that your job allows that. The agency trusts everyone in that whole team to be putting the public's interest first. Indeed, putting the public's interest first is the essence of public service. And I think in this day and age, sometimes we forget that. A fiduciary is also someone who acts on behalf of another. And that's why it's really, really important that the trust and confidence are there. And we've got to understand that in order for us to understand what the very core of your position, whether it's board or staff, is. The obligations in the governmental context, you have a duty of care, of loyalty, of impartiality, of accountability, and to preserve the public's trust in the government. Now, who here wants to have that knock on the door and says, "Hi, I'm here to help you. I'm from the government. Are you going to open that door?" I would hope you have that trust to say that, yes, I will open that door. It is a good thing that the government is here and they are going to help me. That's what you want. That's the kind of relationship and that's the kind of position you should be striving for as a board member. Fiduciary responsibility. While you have not foregone the right to free speech by becoming a board member, you've accepted a larger role and responsibility to put the public interest before your own personal interests. Now, again, your interests and theirs might be completely aligned, but there's going to come times when you're not. So, the connection between a fiduciary and conflicts of interest. The premise underlying conflicts of interest laws is that when a decision maker in a position where they might reasonably be tempted to put their own interests ahead of the public, the best course of action is for them to step aside from the decision-making process. So we look to the Government Code 171 talks about conflicts of interest. I've been appointed to a board. Does that mean I'm a public official? Yes. 171 defines a local public official as a local public official means a member of a local governmental entity who exercises responsibilities beyond those that are advisory in nature. So because you are either acting on behalf of as a staff member or you are a board member and you're making decisions, you are a public official. I'm about to vote on a matter before my board. I personally don't have a substantial interest in the related business entity or related real estate. That's my dad's. Does that mean I don't have a conflict of interest? Yeah, you do. And there's this whole, we're going to see it, whole thing about consanguinity and affinity. So, public officials are considered to have family members' interests. Let's just go with that. A local public official is considered to have a substantial interest in things that if you are related by consanguinity and affinity, you are intoned to have that same interest. So let's look at those. First degree of consanguinity is relationship by blood. First, father, mother, son, daughter. Second, brother, sister, grandparent, grandchild. Third, uncle, aunt, nephew, niece, great-grandchild, great-grandparent. And then we get into the affinities, which is marriage. You've got your spouse. You've got the spouse's mother, father. You've got other people that are all in there, daughters-in-law, sons-in-law, stepchildren. You've got the second level is sisters, brothers, sons, and daughters-in-law, grandfather, grandmother, grandchildren, all in-laws, outlaws, whatever. You've got them all part of it. So there's a large swath of people who you actually have to factor in when you are, and knowing that you're making a decision. If any of them have an interest in whatever it is you're deciding, you are in tone to have that same interest. Okay, so I have a substantial interest. What does that mean for me? It means abstaining. It means walking away from that decision. When you have a substantial interest in real property, you have to walk away. You have to abstain and indicate that you do. It has to be something that is affecting the special economic value of the property and distinguishable from an effect on the rest of the public. You also are to abstain when you have a substantial interest in a business entity, and that means that the business entity, it's distinguishable again from the effect on the public. And there's some demarcations in certain parts of the law that talks about $2,500 or more, or you might be getting, paid or this sort of thing. But just if you have an interest in a business entity and that business entity is going to come before you as a board member, or you're going to have to do work with them as a staff member, understand that you've got a substantial interest. And not that you can't do work, but if you're making a decision about something, you will likely have to abstain. What does abstain mean? Well, first, the exception. The one exception is if everybody on the board or most of the people on the board have the same interest that might be problematic, then you all don't have to abstain, because then you couldn't make any decision involving this. So what are you supposed to do when you abstain? Well, you're supposed to file an affidavit and abstain from voting on it. How is that pictured, though, in real life? And I say this because I've had this in one of my clients before. In speaking with the client, it became apparent that they had an interest. And I said, okay, well, this is what you're going to have to do. You're going to have to file, your affidavit, and then you're going to have to abstain. And for me, I always advise my clients, go out the door. It's safest. This was a mayor, and the mayor informed me that he was going to stay on the dais, but he wouldn't say anything. That was true, except of course, you couldn't tell any of those things. And so I stopped. Mayor, with all due respect, you need to leave the dais. You need to leave the room. No. Yes, you do. All right, I'll go to the back. That's not leaving the room. Well, I'm leaving the dais. It's not leaving the room. I'm going to go to the back. Well, all right, pretend I'm the dais. The rest of the people are looking at the back of the room. It doesn't help. Like, no, you need to get out of here. You are making a spectacle of yourself, and you can't have a say in this. And that's the point. You can't have a say. If you have a conflict of interest, you really have to just walk away. So, what constitutes participation? I would argue constitutes participation as much as, well, I disagree with that, or whatever else might come out of your mouth. So, there's dilemmas. and I have a list of people who will always have these dilemmas as decisions come before you. The district staff, the general manager, the board of directors, the local governmental official board member, the consultants, whether they're employees or contract, attorneys, employees or contract, and then the applicant is going to have the same kind of people, landowner, engineer, consultant, and the attorney. All of these people come into play on any decision that comes before you as a board if you are issuing permits and having these people come forward. So let's talk about the attorneys. Who's your client? That should be a pretty self-explanatory discussion. And we have a litany of lists, and as some of you have seen with some of the other slides that we've had here tonight or today, I'm not going to read all of this. You're going to get these presentations so you can read this if you really care. But we are guided under Rule 1.12 of our rules of all the things that we're supposed to be doing. The organization is the client, and it continues on. And it's very important for the attorneys to be very aware of these. I'm putting this in here, though, because if you are directors, you need to know what they are supposed to be looking at. But let's just say that in the small world of groundwater districts, it may be hard-pressed to find an attorney who comes recommended to you because they know all of the groundwater stuff that may not have a conflict of interest. Something for you all to think about. The role that the attorney has, again, we as attorneys are representatives of you. We are also officers of the legal system and public citizen having special responsibility for the quality of justice. We don't oftentimes think of ourselves in those terms, but we have a really pretty heavy burden when we really, really look at it as to the role we're supposed to be playing. We're representatives of our client. We're advisors to our client. We're advocates to our client. We're negotiators for our client. We're intermediaries between our clients and others, and we're an evaluator for you on things that have a legal basis. When does it come in? Virtually all ethical problems arise from an apparent conflict of interest between a lawyer's responsibilities to our clients, to the legal system, and to the lawyer's own interests. So we as attorneys are constantly, or should be constantly, vigilant in cross-checking these. So we are required under our rules to constantly look at conflicts of interest, and the only way we can do that is through communication. We communicate with you about everything that's going on, and we tell you when everything is happening. We keep you apprised of things, and we're supposed to explain things in a way that you will always understand. We have confidentiality of things that come into us, and we are supposed to keep those things absolutely quiet. Subsection A makes a distinction of what's confidential and privileged, and it falls under a variety of rules. But as lawyers, we know what we're supposed to keep confidential, and quite frankly, that's about everything we know about you as a client. We really should not be imparting things out there in the world that could impact in any way, shape, or form a current client. I say that in the context of, if you have an attorney who has represented several other GCDs, or applicants who come before GCDs, they may have a conflict of interest. Just because they come recommended by another GCD, they may be using different rules. They may have been guided by different rules. We just had a presentation that talked about all sorts of differences that you all might have just in well spacing. So those are things that we all learn about you, and then when we advise you, that's the confidential stuff. We're advising you about things. We're advocating for a certain position sometimes, but we are constantly then having to evaluate, can I say anything about this outside this room? We start to understand under, again, more of our rules when we can reveal and use confidential stuff. Quite frankly, that's never. We are not supposed to be using that for anything other than for you as our client. We're going to keep going through the confidentiality. Again, the rules they're there for a purpose, and that is when you are hiring a lawyer for your board, you should know what we are bound by. Consultants are similarly bound. Hydrogeologists, I'm using them only because, one, they had an institute, the American Institute of Hydrologists, but all of them have these same codes. They have standards for each of the individuals that are qualified in their arena. They establish the ethical standards to help protect the public from irresponsible work, provide education and training in hydrology, and provide public and governmental advice and guidance concerning activities related to the hydraulic, well, that profession. Similarly, they have a code of ethics. It's very similar in nature to a lot of what we have as an attorney. But you need to understand that they have these things. The code of ethics talks about public statements, when they can be made, the professional manner, how they're supposed to work with and build their reputations, and how they're supposed to conduct themselves. Other basic ethical principles are making sure that they act in a fair and honest manner and independent judgment. They make public disclosure of all their personal and business interests that they may have, and in defining that, their personal interests are broad to include any actual or potential benefits or advantages that they have, a spouse, family member, person living in their household might have directly or indirectly. So that can, if you're in a small town and you have a GCD in there, it might be really difficult to find somebody who doesn't have a conflict of interest. They're not to participate as an advisor on any project in which they have previously participated as an advocate, and they are to serve as advocates only when the client's objectives are legal and consistent with public interest. They are not supposed to use confidential information acquired in the course of their duties for any future personal information interest, and they're not to disclose confidential information acquired in the course of their duties except when required by law. They are not to misrepresent facts or distort information for the purpose of achieving a desired outcome. And they're not to participate in any manner unless adequately prepared and sufficiently capacitated to render thorough and diligent service. All of these things are pretty awesome when you stack them up, and should ensure that you have an incredibly good ethical body that's working with you to provide you with the best possible advice and guidance in order to provide you with the decisions that you have to make. But let's just say, despite all of this, I'm a board member and I'm going to vote even though I have a conflict. What's the worst that can happen? Well, it's an offense, a Class A misdemeanor. Oh, it's just a misdemeanor. Well, the punishment is up to $4,000, up to a year in jail, or both. Does that sound appealing to any of you? Offense will not render the action of the governmental body voidable unless you were a time breaker, but it's probably going to make your life a little miserable. The practicalities in hiring. So what do you do? How do you hire either consultants or attorneys in addition to guiding your own behavior as board members or staff members? You interview and you vet. We as attorneys are constantly reminded that we have to do conflicts checks. So in order for us to know whether we have conflicts, we have to talk to you about all the people that might be involved in a case. And it could be current clients, it could be former clients, but we have to really get down into it. How can lawyers recognize and avoid possible conflicts when taking on new clients? We should have a variety, and we do as attorneys, we have a variety of ways, but the simplest one is just asking questions and talking to you and having you be honest about the interplay out there with the applicant and who all they might be representing and who all might be benefited or harmed by that permit that might be coming forward to you or any of the rules. Again, discuss, talk, vet, discuss the purpose of the representation, discuss the known or potential, who the known or potential parties are, discuss the issues that are being faced, discuss the consultants or the additional individuals involved, discuss. You can't help them help you figure out if there's a conflict if you don't. Ask the attorney or the consultant if they've run a conflicts check. Ask them what cases or aspects of groundwater they've worked on. Ask them where they've worked before. Just because they're at this place doesn't mean that was the last place. Ask them if their firm or company represents any of the individuals or entities you will be dealing with. Ask them if their employees or bosses have represented any of the individuals or entities or districts that you have as applicants. You have to be a participant in this discussion, but it's important. I have some slides here of some sample contract language. If you get to that point and you need to put it in there, it will help. It will protect you as a board because what it's doing is ensuring that these things have been vetted, that you've had the discussions and the answers you got showed you that there were no conflicts. So a lot of these are things that you will be able to look at. One of the most difficult things is to recognize that sometimes we too are blinded by our own incentives because we don't see how our conflicts of interest work on us. We want that job. We want to help. I would love to help as many people as I possibly can. I can't. I have to focus on the one client I've got, and everybody else has just got to do the same on their side. But I can't serve too many masters. I can only serve one. Are there any questions?
I do have one question. When a board is discussing an item and they decide to enter into executive session over an item, and there is a board member who has named his conflict and has removed himself, is he able to go into that executive session over that
No.
item? No. Okay.
The safest, again, you could have a mayor or a board member that's going to simply refuse, but my advice is no. They should never go into executive session because the minute you go into executive session, even if it's an executive session on something else and there's going to be maybe two parts to it, you should very clearly have them distinguish what part they're going in on and then be seen leaving when you get to the second part. So no, they should not go into executive session on any portion of it. Abstention really does mean abstention. It means no more. If somebody starts talking about it later, you just go la, 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 and walk away.
Oh,
No, I think they should sign an affidavit. I mean, it helps the district, it helps the person, it helps, I mean, there's no harm in it. The harm comes from if you hide it. So the more disclosure you have for it, the better it is. So sign the affidavit, say what the conflict of interest is, and then go on. And just, again, use these exit signs.
You talked about the fact that an attorney represents the entity. If a disgruntled applicant were to sue a groundwater district and the board members, does the attorney represent the groundwater district and the board members, or only the entity?
As a representative of a groundwater district, my client is the entity. It's not the individual board members. It is the entity. And so if the applicant is suing for something that they did, and there's different levels of this, but board members themselves, as long as they were acting in their sphere of and domain of what they're supposed to be doing, they have some isolation and protection as long as they haven't gone outside that. Ultra vires, they haven't acted outside their sphere of where they were supposed to be. If they haven't disclosed or they have a conflict of interest and they refuse to adhere to it and any of that, then that's their problem. But the entity is who we represent. It's not, the individual board members will be protected under that umbrella as long as they have acted within those parameters. Okay?
any other questions?
She has one.
So
They in essence, the question was abstention and recusal the same thing, basically? And yes, they are, you're supposed to recuse yourself from the decision-making, and you abstain from being involved. And so they're part and parcel, but yes, when you say abstention, it means you are abstaining from further discussion, and you're abstaining from voting. And recusal is in essence the same thing.
any other questions?
Yeah, just real quick. If a board member has a conflict and has a history of voting, of abstaining from votes on a particular permit application or an issue, and then the reason for that board member abstaining then changes, you think that board member could then begin voting on that issue that he previously abstained from or she abstained from?
Could you repeat the question, Barbara?
So as I'm understanding your question, it's if you have a board member that has previously abstained on a situation, and then now something has happened and the board member no longer feels they need to abstain, and they start wanting to vote on an issue involving that very same previous problem. Well, under the conflicts check that you are looking at, if you have a conflict of interest, it would be that suddenly they no longer have an interest in that company or that interest in the permit holder or an interest in the land or anything like that. That can potentially, but they also know, because they were either a landholder or had a business interest in the company, they still hold that information. They still have that understanding. And so it's difficult for you to say simply because we sold that company, doesn't translate to, and therefore I don't know anything more about that company, I can't put up a wall and suddenly say, I don't know anything about them. You still know things about them. And you still should not bring that into the decision. You may know something about what the price of the sale of the company was. You might know something about X, Y, Z. It may not be pertinent right then and there. It will become pertinent. There will be something that will happen. And so it's really hard for you to say, I mean, we're not the AI. We can't erase a certain portion of that out of our memory. It's going to be there. So I would offer, if that were my client, I would say, no, you've started this path, you still need to abstain.
Any other questions? Okay, thank you, Barbara. Yeah.
Oh, thank you.